Hi, Assalamualaikum and very good morning to Madam Nabila. So, today, we want to present about our subject Law 3133, question 4, about the topic of class meeting, variation of right and minority protection. So, this is our group member. So, the presenter A is HAZIQ ADAMI bin ABDUL Azim. Presenter B will be conducted by ANIQ FIRAS bin AHMAD and Muhammad Aizam bin Muhammad NAZERI as a presenter C. So, this is our selected question, which is Company G issued both ordinary share and the preference shares. The company later passed a resolution at a general meeting to vary the rights attached to preference share without holding a separate class meeting. Preference shareholders object, claiming the variation was invalid and unfair. And so on. Will we discuss about the topic with this question A about analyze the legal requirement governing the variation of class right under the Company Act 2016. Question B about whether the resolution passed by the company is valid in the absence of the separate class meeting. And question C is about explanation how the law seeks to protect minority shareholders of their class right are affected.
In modern corporate practice, companies often issue the different class of shares, such as ordinary share and preferred share. To attract investors with a different interest, each class has specific rights, including voting power, dividend entitlement, and priority in the capital repayment. These rights are important because they give a shareholder real financial and decision-making power. Legal issues arise when the company tries to change this class right. If changed can make it too easily by majority control, minority shareholder may face financial loss and unfair treatment.
Now I will explain whether the company complied with the legal requirement governing variation of class right. A variation of class right is any change or alteration to the special right attached to a particular class of shares, such as preference shares. This right may include dividend priority, voting right, and binding entitlements. The purpose is to give flexibility to the company in managing share structure. However, the law provides strict procedure to protect shareholders from unfair changes. Under Companies Act 2016, the main legal requirements are first, authority in the Constitution or term of issue. The first legal requirement is that any change to the right attached to a class of shares must comply with the procedure stated in the company's constitution or the terms under which the share were issued. This is provided under Section 91, subsection 1, which states that the class right cannot be varied in accordance with the company's constitution or the shares term. This requirement ensures certainty and protects shareholders' expectation. Second, concern of the affected class of shareholders. If the constitution does not specify the procedure, the company must obtain approval from the shareholders of that class. Under Section 91, subsection 2, the variation must be approved by written consent of at least 75% of the shareholders of that class, or a special resolution passed at a separate class meeting. This ensures that only the affected shareholders decide on that change. Third, separate class meeting requirement. Holding a separate class meeting ensures that only the affected class of shareholders can decide on the variation of their right. This prevents ordinary shareholders or other majority group from interfering with the decision. This requirement is provided under Section 91, subsection 2 of the Companies Act 2016. In this scenario, Company G failed to hold a separate class meeting of the preference shareholders. Therefore, the variation may be invalid due to non-compliance with the statutory procedure. Fourth, right to object and apply to court. Shareholders who disagree with the variation have the right to seek protection. Under Section 93, subsection 1, shareholders holding at least 10% of the affected class may apply to the court to cancel the variation. Under Section 91, subsection 3, the variation does not take effect until the court decides. This protects minority shareholders from unfair or oppressive changes. And lastly, right attached to share must be clearly stated and protected. The law also requires that the right attached to each class of shares must clearly stated and legally binding. This is supported by Section 91, which provides that this right must be stated in the Constitution or term of issue and cannot be altered arbitrarily. In this case, Company G passed the resolution at general meeting only. The company did not hold a separate class meeting of the preferential holders, and there is no indication that 75% with consent was obtained. Since preferential holders form a separate class with specific rights, such as dividend priority and voting right, the approval is legally required before any variation can be made. Therefore, the company failed to comply with the statutory procedure. The objection raised by the preferential holders is valid because their right were altered without proper approval. Furthermore, if the variation reduces their financial or voting right, it may also be considered unfair or prejudicial. In conclusion, the variation of preferential right by Company G is likely invalid because the company did not comply with the legal requirement under Companies Act 2016. Preferential shareholders have the right to challenge the variation in court, and the court may set aside the decision if it is found to be improper or unfair. This case highlights the importance of following the correct legal procedure when varying class right to ensure fairness and protect shareholders' interests. That's all from me. I pass to the next presenter.
For this issue, the resolution passed by the Company G is likely to invalid because any variation of class right must strictly follow the statutory and constitutional procedure. Under the Company Act 2016, the right attached to preferred share cannot be varied without obtaining approval from the particular class of the shareholder, such as approval is normally required either through a properly convened spirit class meeting or through the written consent to prescribe majority of the preferred shareholder. The purpose of the requirement is protect mandatory class shareholder from any unfair alteration of their right by the majority. In the situation, Company G is only passed the resolution at the general meeting and failed to hold a spirit class meeting for the preferred share. As a result, mandatory procedure required is not complied with. Therefore, the preferred shareholder have strong ground to challenge the variation in court. In conclusion, the variation is likely to be declared void or set aside for being procedurally improper and unfair.
Hi, Assalamualaikum and good morning to Madam Nabila. So, my name is Muhammad Aizam bin Muhammad Nazri. My ID number is AM2505019401. So now, I will continue to the question C, which is explain how the law seeks to protect minority shareholders when their class right is affected. First of all, who is the minority shareholders? Minority shareholders is an individual or an entity that is holding less than the 50% of a company voting share, but often considered as a significant minority at 25% or less. That means they lack the direct control over the corporate decision, management, or the board. So, how can law protect the right of minority shareholder when their rights are affected? Under the Section 292 Company Act 2016, the first method that law can protect them is by the mandatory consent requirement, which means any variation of class that come from the company must be approved by a special resolution of that particular class at a separate class meeting, or they can make a written consent of at least 75% of the holder of the class. The other shareholders cannot decide for them. So, if the case is just involve the preference shareholders, then only the preference shareholder that can decide that. This means, for example, if one of the company has the preference shareholders that has the fixed dividend that the company must pay, but suddenly the company wants to remove or reduce that right, the affected shareholders can cancel the variation via a special resolution at a separate class meeting, or they can make a written consent of at least 75% of the holder of the class. Next, law also provide a right to apply to court. Under the Section 193 Company Act 2016, the law give the affected shareholders the right to apply to court if at least 10% of affected shareholders do not consent to the variation. The court can immediately cancel the variation. Also, the court may disallow the variation if they find the variation is have the unfairness, discrimination, and not made in a good faith that to the affected shareholder. Last but not least, the law also provide the affected shareholders the protection against oppression. What is oppression? Oppression means when a person or group in a position control the powerful in cruel and unfair ways. So, it can be a common in the company case example. Under the Section 346 Company Act 2016, minority shareholder may also rely on oppression remedies under the Act of the conduct of the company is oppressive, unfairly prejudicial, and disregard their members' interests as a member. Who can apply the this protection? Just the affected shareholders also just can apply this protection. And for the common example of the operation is like irregular financial transaction, mismanagement, or non-payment dividends to the shareholder. So, what the law can provide from this? The law can provide the remedies that can affect the company itself to protect the minority shareholders' rights, such as the ordering a buyout of share, restricting the company affairs, or winding up the company. So, that's all from me. Thank you.
In the conclusion, the resolution passed by the Company G is a very right of the preferred shareholder is slightly invalid because it's not comply the mandatory requirement under Company Act 2016. The company failed to hold spirit class meeting or obtain the required 75% of the consent of from the preference shareholder under Section 292. The law also strain protection by allowing distinct shareholder to apply to the court by providing remedies against obtrusive or unfair conduct. This safeguard help prevent abuse of the majority power and promote fairness, transparency, and accountability in the corporate decision making.
I have a question for both of you. For the first question, I want to ask Aizam, why do you think the law requires a separate class meeting before changing shareholders' right? And the second question for ANIQ, what can happen if companies are allowed to change class right without shareholders' approval?
So, my answer for the question is the law requires a separate class meeting to ensure the fairness and protect the interests of the affected shareholders. Since the different classes of the shareholder has the different right, then only the shareholders whose right are affected should have the power to decide whether those rights can be changed. Thank you.
For the question, if the company is allowed to change class right without approval, it may lead to unfair treatment or an abuse of power. This could result in loss of trust, shareholder disputed, and legal challenge against the company. Alright, for the Q&A section, I have two questions. Firstly, for HAZIQ, why must a company obtain approval from the preference shareholder before varying their class? Right.
Based on my understanding, because the right attached to preference shares are legally protected and any change affect only that class. Approval ensures that shareholders whose rights are affected agree to the change.
My question is, what is the at least percentage of the affected shareholders that do not consent to make the court cancel the variation? My second question is, the board of directors of DEF Berhad proposed to vary the right of the shareholders by removing their fixed dividend. The variation is approved through the ordinary resolution, but no separate meeting was held, and they claim that their right is unfairly affected. Is the variation is valid under the Malaysian law?
My answer is, under Section 93 in Companies Act 2016, the court may cancel the variation if there is 10% of the shareholders that do not consent to the variation.
In my opinion, it's not valid because the variation is approved through the only ordinary resolution and no separate meeting held. Under Section 292 Company Act 2016, any variation of class right must approved by special resolution passed at spirit meeting or written consent at least 75% of the holder of that class.